Okay, so just so everyone's clear, the players for the first hearing, Richard, you're Jerry Galt. Jadita is Mrs. Galt. John is not here, and he's playing his older brother. We'll deal with that in a minute. See if he walks in the next 5 minutes. Joe is not here, who's playing Officer Flagg. But Tim, you're Officer Henderson, so you can pretend to be if...
Joe should be in about 5 minutes.
Oh, he will? Oh, awesome. Okay. Lester, you're the judge, and I'm your clerk. So let's do this. Lester, come on up. And I'll have you sit here at the judge's table. So Lester's, you know, having his lunch, whatever he's doing in just judge's chambers. And what I'm going to do is I'm going to bring in a couple of minutes, Jerry, and the officers will be bringing you from the juvenile home. And then Jadita and Jerry's brother, John, if he comes in, will be, you guys are coming from home. So I'll be escorting them, the two parties in, and letting you know what the case is. And then you take it, from there, okay? Any questions? We'll just wait about 3 or 4 more minutes to see if John and Joe get here. Tim?
Do you have an extra evidence somewhere?
How many did I pass out?
What are you looking for? Evidence?
Yeah.
Sorry.
You don't need, obviously that's to be used for the third hearing when we do the direct and cross-examination of Mrs. Gall. If, let me see, if I really want someone to play Jerry's older brother, so if John doesn't come in after I escort the parties in, I'll just be your son, Jadita.
Okay.
Okay, I'll be Paul, John, the older brother,
okay,
if John doesn't make it. Joe, I'm not that concerned about because Tim, you can play the roles of both of the officers. In fact, it's Flagg that has more of a speaking role here because you're the one who arrested Jerry. You talked to Jerry initially, etc. Right? Anybody have questions?
Is there a conflict of interest with Flagg? He's
absolutely, absolutely.
He's school.
There were all kinds of, but that's why we're doing this first hearing pre-Galt. There were all kinds of things wrong with that case before the Supreme Court decided.
But I don't think
absolutely.
I don't think the case makes any kind of comment in reference to that.
Oh yes, it does.
Oh, they don't.
It in fact does. Mm-hmm. Let's see who this is. Okay, Joe.
Sorry.
Joe, you're Officer Flagg.
Yes.
Okay. Okay. All right. So, what's that?
Nothing like being late to your own hearing.
That's all right. I'm the clerk,
yes,
and I'll bring you and Tim.
Yes.
You're Flagg. Tim is Henderson.
Yes.
Richard is Jerry. So I'm the clerk, and I'm going to bring you guys into Judge McGee's chambers.
Yes.
And then I'm also going to bring in Jadita as Mrs. Galt, and if John doesn't show up, I'll play his brother. Okay? So it's 2 little entrances, and then from there you'll take it. Right?
I'm ready.
Okay. All right. So let's do this. Let's bring you guys in for, and let's have enough chairs so you can be. We'll have, once you come in, we'll have Richard seated in the middle of the 2 officers, and then let me make room over here. Then we'll have Mom and older brother sitting on this side. They would have been sitting in front of you, you know, your desk, and there would be
anybody.
You want to push your chair back so that yeah. And you know what? Let's do this, Lester. Oh, we can't. They're stuck together, aren't they?
These tables are
They're welded together now. Oh,
We
wait.
can move that one over there.
Oh, it's fine. It's fine.
Are you sure?
It's fine. Yeah.
You don't need to take it
I'll
off.
just go over there.
Okay. All right.
I can be.
So I'm knocking on the door.
All right. Enter.
Hi, Judge.
Hello.
Sorry to interrupt you, but we've got the Jerry Galt, the people coming in on the Jerry Galt.
Let's have them.
Okay. Come on in. You know Officers Flagg and Henderson, and Mrs. Jerry Galt.
This is a little punk. All right.
Good afternoon, Your Honor.
Good afternoon. Why don't you guys have a seat?
And I believe that Mrs. Galt and her son, her older brother and her son Jerry's older brother is coming too. Is it okay if they come in?
It's fine, although they
Okay.
don't need to be
Okay.
here for this.
Oh, I'm sorry.
It's
I'll go get
fine,
her.
it's fine.
It's fine.
What are you,
Go
comfortable?
ahead and Mrs.
Yeah.
Galt.
Thank you.
Keeping an eye on me as a habit of escape.
And Paul Galt.
Madam, have a seat.
Thank you. Awesome. I missed you.
Sonny.
Jerry, when they get you home, I can kill you.
Oh,
Be nice.
now look, we're
I'm sick
Be
of
respectful.
running after him all the time.
civilized, even though this is not a trial or a official hearing. I'm not even gonna take notes. So, Officer Flagg, why are we here?
Yes, Your Honor, we're here today, reference to a petition that I filed with the court. In this case, Jerry here, sitting in front of you, made some lewd phone calls to a Mrs. Cook, and ultimately, caused alarm to her. And
Where is she? How come she's not here?
Please, Mrs. Gold, please allow me to conduct this meeting.
I know.
Is she
but-
coming later, Judge?
Yeah, because if she's accusing my son, then shouldn't she be
Right,
here?
all right, listen, this is not a criminal proceeding.
So
First
then
of
why
all.
is he cuffed and?
Well, can we uncuff this child?
Thank
Thank
you.
you.
Are you okay, honey?
I want to
Are
come
you
home.
comfortable?
I want to come home.
Mrs. Gall, please allow me,
No problem.
Judge McGee, to conduct this session.
Okay.
It is not a trial, it's not a criminal proceeding, it's a civil matter, and we're just meeting in chambers. I'm not even having my secretary record this, so. Young man, did you hear what the Officer Flagg said?
Yeah, but I didn't do anything.
What did you do?
I was home with my friend Ronald. And
Instead of going to school, Jerry, right? Judge, I'm sorry, my dad couldn't come here today, so I'm here in his
Yeah,
place.
but
And I
listen,
take care of Jerry. Can
I
we just
know
bring
you
him
do.
home?
You're
We'll
a
take
big
care
brother.
of him.
You're a good boy, but I will ask the questions if you don't mind.
Let's let him ask. Let's see what he's gonna say.
Now, young fella, did you insult this neighbor? Did you make lewd, whatever he said?
No, we were.
Why? You say yes, you say no.
But how can he say yes? He didn't call him. What's the person that's accusing him?
This
That's why
is
she should
gold.
be here.
This is gold.
But we didn't.
Please.
That's why she should be
We,
here.
we were
Mom,
home.
did you get any papers? What does
They
the
didn't even
paper
give me
say?
any
What's he?
Hush, please. Now, the officer here says you made some naughty remarks on the telephone to your elderly neighbor. Is that true?
No,
Well, what is true?
we were home and we
Who
kind
is
of,
we?
me and my friend Ronald, and we kind of had nothing to do. So we were just messing around, and I dialed the phone number, and it was for a lady I know. Sometimes we help out around her house, and I called and I gave the phone to Ronald. Ronald said he wanted to talk to her. He
Yeah.
said some vulgar things, I guess, but I didn't say anything.
You did. Officer, why is this child here accused of this?
He did in fact make the remarks, and
Were you there?
no, I was not there.
So how do you know?
Mrs. Galt.
Yes, we received, Mrs. Cook had informed us of the allegation, and ultimately, we came forward with a petition to you, an affidavit in support of that, which you have.
Mrs. Galt, is there anything you would like to say in this
Yes,
matter?
there are a lot of things I'd like to say. First of all, He was not there. How can he say that it was my son? My son says that he didn't do it. And you can't differentiate the voice. He wasn't there. That's why Mrs. Cook needs to be here to say, you know, she needs to be here to say what happened.
Right.
And then on the other side of the phone, how does she know that it
hold
was my son?
on. Mrs. Cole, the police are never at the scene. or
I
something.
get that.
You
But
know,
then the accuser
so
should be here.
yeah, he is. But Officer Flagg, he's an officer in the court. He's a probation officer. He's on the board of the juvenile home,
I get that.
and he's not here. This is not a criminal matter, and the police are never on the scene of it. Now, is there anything else?
Yes, but he's on the board of the juvenile home, so don't you think he would want my son to be there? You know, maybe the state's going to give him more money for more children that are there. And
Look,
again,
the state's not going to give him more money, but beyond that,
beyond that, I think my son should be able to come.
Wait, I have a line. The purpose of the probation officer and the juvenile detention facility is in the best interest of the child. It's to rehabilitate the child. It's not to punish.
But what is he being rehabilitated for? He doesn't have a problem.
Well, I don't know. My recollection
I
is
just want
It
to
was
come
already
home.
on
Is he being
probation
charged with
for-
anything? Because if he's not, I think he should be able to come home tonight.
this officer here. What's your name, officer?
Officer Henderson.
Officer Henderson. That's right. I forgot your name.
He's currently on probation for being involved in stealing a gentleman's wallet.
Yeah, we get that.
And he's
but-
been pretty good, you
Right.
know, up
I was
until.
just
yeah,
there. I
he
didn't
go-
take anyone's wallet.
So you didn't take the wallet, but you were there. You didn't make the call, but you were there in your own home. Listen, fella,
But is he being charged with something? What is he being charged with?
but this is not a legal.
Then he should be able to come home. If he's not being charged with anything, why is he being held?
Well, I'm going to answer you
Okay.
because it's in my discretion as the judge.
Why
of
aren't you
the-
wearing a robe?
Shake it up.
I'm in chambers here. I don't need to
Relax,
wear my.
Why are
Fair.
we in your room? Why didn't we go to the courtroom?
Well, listen. Before we do anything official, I'm here kind of as a fatherly figure, even though his child has a father, I know that, to sort of move this along in the right way. We
I have
don't-
older friends that when they get arrested, they get a lawyer. How come Johnny
Right,
doesn't have a
we
lawyer?
don't have to follow the Constitution. We don't have to do all that.
Why?
Well, because the
We
tradition.
don't follow the Constitution.
Yeah, I know. The tradition for a matter involving a 12-year-old.
He's not 12.
How old is
I'm
he?
15.
15.
Oh, 50, I beg your pardon. I was thinking of a former case. But
We should get the judge.
we don't have to follow the procedure by the Constitution.
And why
It's
is
not
that?
an
He's a
adult
person.
matter.
But he's a person. He's human.
Yeah, he
Constitution
is
for all
human, that is true. But the history of juvenile proceedings is not the same as for adults. And we're not held to the
So
same.
will he have a trial in the courtroom?
No, he's not going to have a trial. He doesn't need a lawyer and all that due process stuff. We don't have.
But okay, you're telling me he doesn't need this, he doesn't need that, he doesn't need a
So-
lawyer, but he's being held as a criminal. Why? That's what I need you to tell me, Judge.
Right. Well, these questions.
Deserve answers.
Judge, if you let him go home with us today, we'll make sure he goes to school every day and he comes back,
Oh, we will.
sees the probation officer as he was seeing him anyway because he had been on
I'm sorry,
probation.
Mom.
Oh, you better be sorry. I'm gonna get you and get home.
Yeah. Listen, Mr. Young fellow Galt there and Mrs. Galt. The child, didn't you admit to making some lewd remarks?
He just said he didn't do it.
Well, hold on. Didn't I see that in the police report? You admitted it.
No, I picked up the phone and I dialed it, but Ronald said everything. I mean, I might have said some things in the background. I was just joking.
Didn't he admit it, officer?
Your Honor, he did admit it, and it's in the pleading that you have in front of you there, the affidavit, and ultimately, I submit to the court that we'll take good care of him at the boys' home. We're gonna
Why
help rehabilitate
don't you
him.
ask
Yeah,
Mrs.
why
Galt?
don't-
She knows my voice.
You mean Mrs. Cook?
Mrs. Cook, she knows
Yeah,
my
because
voice.
Mrs. Galt is your mommy, she ought to know your
Well,
voice.
you're not wearing a robe.
All right, you know what? This matter is in my discretion. And so I am going to decide right now, I'm not putting anything in writing, that this young fella is gonna go to the juvenile home with probation officer flag.
Thank you, Ron.
But wait a second. Wait a second. How come Ronald is not here?
Listen.
No, that doesn't make any sense, though.
I know.
My child should be able to come home tonight.
Right, but this child admitted to making these lewd remarks to the officer, and I'm gonna accept that.
Jerry, did you do it? Tell your mother the truth. Did you do it?
No.
I'm gonna accept the probation officer's affidavit, and he's gonna spend some time at my discretion under the authority of the state in order to rehabilitate and help him, and that's my fatherly advice.
I'm sorry, but you just told me that this is not some kind of official hearing. So how do you get to make a decision like this without having my child, given his constitutional rights?
The state of Arizona permits me to make these decisions at my discretion, and this is the decision I'm making.
You're wrong, Judge.
What's this?
Oh.
All right, we can go off the record for a minute. Why?
Thank you, Ron.
It's just all wrong. I mean, but I'm sorry, I forgot this is chamber.
But this is what Judge McGee.
No, that's what he did. We're just playing it out the way that
No, I'm glad we went off the record for a
The
minute.
judge was stupid,
Yeah,
Very.
very stupid.
and I am playing that part perfectly.
Let's go with it.
Everything you guys have been doing is great, except you didn't make your final decision today. He went back to the home for a few days.
Right,
Remember
and
that?
then
Yeah,
he came in.
yeah. So in terms of
Well, that's why I said-
committing him now.
Oh, I
so
didn't
what you want?
forget.
Oh, okay.
I didn't forget.
So you
The
want
ch-
us to go away as soon
Yeah,
as
the
you can. Maybe
child-
the clerk is going to come in and knock on the door
Yeah.
and escort these guys out
Yeah,
first.
clerk, are you gonna come in?
And I'll come in a second.
Okay.
And you're letting the Mrs. Galt know that he'll probably be home in a couple of days, and yes, there will be another hearing later on.
Yes, and
Okay.
Mrs. Galt, this is an informal meeting in my chambers. We're going to have a more official proceeding. It's a civil matter, it's not a criminal matter. You don't need lawyers or evidence or anything like that. But for until that happens, this young fella is going to be under the.
I'm not a
Judge,
yes,
you
yes,
wanted
clerk.
on another matter, you have a phone call from the Supreme Court of Arizona.
Okay, I'm going to speak to.
Come on, Jerry, let's go home.
No, Mrs. Galt, my clerk, thank you, clerk, will escort you out. Officer Flag,
Oh, yeah.
Officer Henderson, will you take this young fella?
Let's not go ahead.
Mom, you're on it.
Don't abuse him in any way.
No, we won't. Trust
Let
me.
him simmer
We're really good at the
down.
home. There's been no investigation.
Let him simmer down. Put those billy clubs away.
That was excellent. Very good. So again, let's just, before we start the second hearing, so the second hearing is the analogous hearing to this one. It's the arraignment. It's the first time Jerry would be in court.
Is that in front of me, Judge McGee?
No,
No,
all this-
yeah.
You're here though, you're my clerk.
Oh, that's right. Is this the habeas corpus hearing?
No, the arraignment.
Oh, well, I'm not. Oh, I'm your clerk.
Yeah, you're my clerk.
Great.
So, what Jerry was denied, and Mrs. Gall was denied at this initial hearing was what?
Due process.
Yes, sir.
So again, procedural. Due process.
No charges, no lawyer.
Yeah, so is process due? Yes, it is, because it's Jerry's liberty that is at stake. And because it's liberty, the process that should be due is the most.
There has to be a
Right.
written notification.
So, notice, and notice goes to not only the advance notice of the hearing, but also the specific charges. Remember, Jadida, you were asking, what is he charged with? It was just this general delinquency
Right.
complaint. And then we started asking, I think I did, is Jerry's brother, doesn't he get a lawyer, right? And then you did very good, Jadida, with the Sixth Amendment, confrontation, cross-examination, which we'll see in our third hearing, right? Mrs. Cook wasn't there. We didn't talk much, I don't think this hearing considered, well, absolutely did, never mind. You kept asking Jerry stuff. And also, even before that, when the officers were investigating, again, he spoke without having his Fifth Amendment right against self-incrimination, according to him. So now, we're going to do his first Richard, question?
Is the next hearing the August hearing?
No. We're done with the Jerry Galt case that went up through the Arizona courts. Now it's Jerry Galt again, but Jerry Galt in the future, today, right? So we're doing two hearings. One is the arraignment of Jerry Galt in open court. He appears before the court for the first time, and because he's charged with. And later on, when we do the juvenile delinquency cases, we revisit Galt again. So this is an introduction to it today. So you would be charged with delinquency by reason of, in the specific charges, having made phone calls in, violation of this particular criminal statute. Parents and Jerry would have had this notice. Okay? He may or may not have been arrested, so he may be coming in with mom and dad and the brother, if he's around, for his arraignment, or he may have been picked up, and then he would be, detained until he comes in for his arraignment. So at his arraignment, he also gets right to counsel. Right? So in Massachusetts, for example, if you're a private lawyer, you can be paid by an agency called the Committee for Public Counsel, right? And you're certified to take cases like this by doing ongoing, continuing legal ed and getting so many credits per year and so forth. So whoever plays the attorney here, who's Jerry's attorney? Oh, Patricia and John. Okay. And John's not here, so just Patricia. So this would have been your duty day. You're meeting Jerry actually for the first time in court today. So if he had been in lockup, you'd be going downstairs to see him, to interview him briefly, and then you'd hold the case for the second call, and then you'd come before the court for his arraignment. Now, the only thing that happens is at arraignment is these preliminary things. The notice, the notice of the charges. What Galt didn't talk about that happens today as well, because it's very similar to a criminal adult trial in terms of due process. While the individual states don't have to afford jury trial federally, because there's a Supreme Court case of MacGyver v. Pennsylvania held that because juveniles, because there's still the philosophy of rehabilitation, parens patriae, the informality, in spite of some due process protections. The Supreme Court doesn't go all the way and give what's called the full panoply of due process rights. But Massachusetts, like Massachusetts is, frequently affords more rights to defendants in its state courts. So juveniles in Massachusetts, actually do have the right to jury trial. So another thing that happens at his arraignment, so he's informed of all his rights, the right to counsel, which he can waive. He might say, no, I don't want you Attorney Stillman, I'm going to go on my own. I may even decide to plead it in the same day. You're informed of your right to jury trial, which again you can waive as a juvenile. But because you're talking about, as the Galt case did, the notice going, these rights going not only to the children, but since the parents have custody as well, even though they're not parties, they participate, obviously they participate in the process. So if the juvenile is going to waive his right to jury trial, the judge has to make sure he or she understands that, and the parent would sign along with the juvenile. And another issue that comes up on arraignment, same as adults, is Richard, Judge McGee didn't allow you to go home for no reason at all. Okay, but this judge now, post Galt, to decide to hold you, there has to be a legitimate reason. Okay, so bail issues come up. You know, what ties do you have to the community? So, you know, mom and dad, you know, work. Is there anybody to watch after school? And that's where Jerry's brother might come in. You know, I'm there to make sure he comes home or whatever. The seriousness of the charges. How serious is making, you know, a phone call like this? As opposed to, you know, if you had, were charged with rape, for example. Jeremiah?
So, okay, I'm confused. So today in our roles,
Right. So
playing
what,
this as if Galt hadn't been ruled by the Supreme Court.
it had, right now, had, yes. This is your post-Galt arraignment.
But
that we're doing now.
the same facts as Galt already.
Same facts,
So
same
just
facts.
replaying it, but as
Yes,
if-
so Jeremiah, you're the district attorney, right?
Yeah, so now
So one thing you're gonna be doing on arraignment too, I still wanna hear enough of the facts of the case to decide whether he should be held or not, to decide issues of bail. He's gonna plead, you know, not delinquent, so he's not gonna do, you know, he's not gonna do a plea today, which he may have done. So I'm gonna hear from you as to the nature of the charges, and I'm gonna hear from probation. Who's probation? Oh, you two again, right?
Yeah.
Okay, why don't we do this? Stick with your job, Joe, as the arresting officer, and I may not hear from you because Jeremiah will be summarizing a lot of what you already know. But Tim, I'm gonna have you actually come and sit here because you're probation. So you're sitting, you know, up on this side of the judge's bench. And I'll hear from you after I hear from the attorneys relative to, you know, the issue of bail. Should he be allowed to just go home with his parents today, rather than, you know, having him held? So you would be talking about his previous history. Any questions so far while I'm summarizing what's going on? So again, this is the arraignment post-Galt, same facts as Galt.
So I'm just arguing why he needs to stay in the state school.
Yeah, exactly. Patricia assumed that, you know, you were appointed early in the morning and you got a chance to talk to him, you know, talk to his parents and so forth. Okay. So again, you would be, you know, making a bail argument against the I don't know what you want to do, Jeremiah. If you want to assume that, I don't know. You've heard from probation that.
Well, I'll do a brief summary and then probation can go into the details, especially with regards to the previous. Because in my head, that's going to be part of the argument.
You can make it a little gray, Tim, in terms of, because if he actually violated his probation, there would be a different type of hearing as well. There would be a violation of probation hearing. But when asked by the judge, you could say, well, you know, he missed a lot of appointments. He's supposed to do, I don't know, some community service, but he hasn't completed it. He hasn't quite violated. But you're a little bit,
Big.
and you're a little bit angry with his
Behavior.
with his behavior relative to probation. So make it a little bit so we can be, you guys can be arguing. So that will be this arraignment hearing, and then after that, then we'll commence, which would have been obviously, you know, months down the road, although he has the right to speedy trial. So after his arraignment, whether he goes home or not, there are other, you know, he may appear before the court on other matters like motions, a pretrial conference. But what we're going to do is as if it was that little piece of the trial where the victim actually does testify. Okay, are we ready? So Tim will be sitting up here as probation, Lester as the clerk, myself as the judge. Lester's going to call the case. Now here's the other thing. It's these are closed courtrooms. So delinquency cases, which are cases heard of children who have violated either the general laws or local ordinances between 7 and 17. Closed hearings, the only parties allowed in the courtroom are parties that have something to do with the case itself. So the actually court officer would have called the case. I mean, in Lowell they call it by number rather than the names. So when the if Jerry had come in with his parents, he would have had to check in with probation first, and then he would receive a number. So say there were 20 cases on that day. If he was number 19, he'd be waiting out in the hallway. Again, if he was held, he'd be downstairs in lockup. He'd be waiting outside in the hallway with his parents and his brother, if his brother's there. And then the court officer would be walking through and say, case number 18, come on in. District attorney, you'd probably be already in there because you would be engaging in the previous case. Although that's not always the case, because the case before might be a neglect and abuse case, and that's not the district attorney's office, but Department of Children and Families attorney. So you may or may not have been in there, before. You might have been in another courtroom. And so, same with Patricia, if you were the attorney on duty for the day, you might have had a bunch of cases on that day, so you might already be in the courtroom. In any event, the lawyers introduce themselves to the court. The judge will also ask who else is here. Now, another thing about the opinion itself that I wanted to point out is the majority opinion has a nice summary of the historic, the juvenile court movement, the history of the movement, and then the dissenting opinion has sort of the other side of it. So this conflict between, and the conflict still exists today, and is actually the reason for the adolescent development studies, and ultimately the Supreme Court holding the death penalty unconstitutional and the mandatory life in prison unconstitutional. It's still this ongoing battle about, is it civil, is it criminal? Should it be informal, like in pre-Galt? You mentioned the paternal or maternal, judge that wants to do what's best, or should it be adversarial and more formal with all of these due process rights? Proponents like, Stewart in the dissenting opinion would say, the more rights that you give, the more adult-like the cases become. And then, what are you doing in the juvenile court at that point? What the whole reason for the juvenile court is to help kids. In fact, there's this great quote by Stewart that almost at the very end of the opinion, when he says, to impose the court's long catalog of requirements upon juvenile proceedings in area of the country is to invite a long step backwards into the 19th century. In that area, there were no juvenile proceedings, and a child was tried in a conventional criminal court with all the trappings of a conventional criminal trial. And he talks about a specific trial. So it was that a 12-year-old boy named James Guild was tried in New Jersey for killing Catherine Beeks. A jury found him guilty of murder, and he was sentenced to death by hanging. The sentence was executed. It was all very constitutional. The juvenile court, even today, with all of the due process rights that is afforded children, is still more informal than adult courts. So in spite of all these rights that we talk about, you'll frequently see judges and attorneys as well being, more informal. In the middle of the trial that we do afterwards, the attorney might be asking questions. Sometimes the judge just interrupts and asks his or her own questions. That you don't see something like that often in the Superior Court or the District Court, for example. So keep that in mind. yes, the proceedings have become more adversarial, more formal. This whole constitutional rights era of Galt and all the post-Galt cases, but it still retains a lot of the parens patriae philosophy and goals of the court. Sometimes you'll see the judge actually come down off the bench and talk to the child. Not infrequently. You will see things like that. All right, enough talk by me. So, Tim, probation. Lester's my clerk. Lester's going to call the case. Everybody's going to introduce themselves, and I'll take the ball from there.
Hear ye.
Oh wait, Cassandra has a question.
But the father doesn't play a significant role.
Well, who, your father?
Oh.
Yeah. We'll see.
Okay.
We'll see.
I mean, I'll be the
Take
parent.
your cue from me.
Okay.
Right?
Okay. But we have to go past
So
do we go?
Tim, why don't you sit on this side of me?
side?
Yep.
You would leave your son.
Here.
Yeah, pull up a chair.
After this, we get a
Actually, Lester should sit closer to me. You sit on the other side.
Well, for the course
And I'm further behind, too, right?
Joe, you would actually be out
On the
there.
audience, yeah.
Yes,
Okay.
yes, because you were the arresting officer. You might be handing, the most that you might end up doing is handing Jeremiah the police report.
Yeah.
What do you guys want to do? Do you want to assume, Joe, that you're bringing Jerry in from lockup?
I would like to come from home.
You want, or you want to do it as if you had been?
I would hope presently that you get sent home for a harassing phone call complaint.
Okay, all right, all
It's not
right.
about the phone call, it's about your visually immoral behavior.
He's coming back anyway, so. No,
Okay, so let's assume,
to reoffend.
and who's Mr. Cassandra? Okay. The rest of you pretend you're not here. Well, you guys are here, the lawyers. Nadezhnaj,
You said that very condescending.
I did. What role do you have
Juvenile court probation officer?
in? Oh my goodness, I just screwed up, didn't I?
Probably in the third hearing now.
For the third hearing.
I think.
No, come on up. Join Tim. You can both be probation officers.
Oh.
Yep. And that's frequently the case too. Usually there's a couple of them sitting there, 2 or 3. Ash?
Mrs. Cook.
Oh, okay,
I'm
all right.
waiting.
Why don't you can stay right there, but why don't you assume that you were in the hallway and you were the court officer and just call it case number 18 coming in, and then they all can come in. All right?
Be an officer for this one?
You're a court officer.
Okay.
Yeah. And also, I mean, your responsibility, you're gonna come in with them. You might stay in the courtroom, so if anybody acts up, I might look to you for help. I'm assuming they won't, but. All right, we're ready? So I'm already sitting down, you're already sitting down. So you would be, again, Lester's my clerk, but he would have been, in front of me somewhere. I'm up on the bench, and these guys are usually at another desk themselves, the probation. And actually, Patricia and Jeremiah, you're sitting too close together for opposite sides. Can I move you guys? Can I have, is there an empty seat somewhere? I'm going to have Jeremiah move over because you would be on this side of the courtroom, if you don't mind. And Patricia can stay where she is.
Will the court officer please call the case number?
Is that me?
Yeah.
It's you.
So, I'm sorry,
Okay, so you would have been in the hallway, Ash.
Okay.
You're the court officer.
All right.
All right, and in the hallway, you're assuming there's everyone's milling about. Families, children, lawyers talking to their clients, and you're walking through and you're going, case number 18! And then you're bringing them in, and you could just stay in, then you could be seated.
Okay.
You could stay. All right, ready?
I call case number 18, Jerry Galt.
Okay.
You guys can.
Is the idea to use a number?
So there's a door, and you're coming in.
Is the idea to use a number so you're not identifying?
Exactly.
Opening the door, Jerry has a police report.
Jerry has to go with me.
You're not in custody. Hey, we're further down.
Yeah, Jeremiah, sit where there's an empty chair on this side somewhere.
There's a police report.
Thank you. Just sit next to your dad.
Perfect. Right there. You can sit in Lester's seat.
Fine, no, sit next to me, son. Actually, you can sit next to the lawyer. Son.
Jerry, you should probably sit. You probably should sit
Yeah, sit
next to
next-
your lawyer.
Oh, okay. So let me move down one.
Now, Jerry and his lawyer are probably sitting at council table, again, a little closer to me, whereas the participants may not be, maybe a little further back. They may be in the bench is in the back. And Jeremiah is to my right. He represents the district attorney, and he'd be seated at his own council table. He might have another ADA with him. In this case, you're just by yourself today. So once they come in and sit down, then you're opening the, Lester is the clerk, he's opening the case file. Then he's calling the case. So then the attorneys both stand up and introduce themselves, who you are, who you represent. And then I will ask who else is here, and they will identify themselves by themselves, okay? All right?
Your Honor, hear ye, this is the case of Commonwealth v. Galt, State of Arizona, I should say, v. Galt.
No, we're in Massachusetts.
Oh, Commonwealth v. Galt, with the representatives of the parties. Please rise, introduce yourself.
Jeremiah McIntosh, District Attorney's Office.
Tricia Stillman representing Jerry Gold.
All right, thank
Hello,
you.
Jerry.
Your Honor, shall we proceed?
Jerry, is that your parents in the back?
Hi, Your Honor. I'm Jerry's mom, Marjorie Gold.
Nice to meet you, Mrs. Galt.
And I'm Mr. Gall. I'm his father.
Nice to meet you, Mr. Galt. Hi, officer.
Good morning, Your Honor. Probation Officer Flagg, I appear on behalf of the state for probation.
Okay, thank you.
And
I'll hear from...
with the probation
no,
department.
they don't introduce themselves.
Oh, they don't?
No, they
You guys
hear
just sit
all
there,
the
be
time.
quiet.
I'll hear from you, Attorney Jeremiah.
It's the position of the Commonwealth that based on this juvenile's record, that he be remanded into the custody of, you still want to call it state industrial.
What's he charged with, counsel?
Delinquency. He has a record. He made
By reason of what?
lewd phone calls.
Okay. What's the
Completely
nature of
unacceptable.
the, could you summarize the facts for me?
Sure. Juvenile was with another friend, also a juvenile. It's according to the police report, which I believe is over there. He decided to prank call. The two boys decided to prank call a neighbor. Mr. Galt actually picked up the phone, dialed the number, and then it's kind of gray from there. Who said what? He admits to saying stuff in the background, but he basically, not to disrespect Your Honor's court, but I guess the word used was hoe. Called the neighbor a hoe. Some other disparaging comments of such nature, and the lady called the police, reported the phone calls, and he was picked up and remanded into the state industrial school. Is that what they call it here, Matt?
He's actually here in the custody of his parents today, isn't he?
Oh, that's right.
He was released?
Yeah, he was released.
Okay.
And we think he needs, it's the Commonwealth's position that he
I'll
needs
hear
to
you on
be-
the question of bail afterwards, counsel, thank you.
Okay. Sure.
Attorney Stillerman, how does your client plead?
My client pleads not guilty. I'm sorry?
Not
Oh, not delinquent. He didn't do the action in question that he's been accused of, that he's been kept in custody.
So you'll be proceeding, I'm assuming that you want continuance for a motion. Do you need a motion day?
Yes.
Clerk, can you look at the calendar for me?
Yes, Your Honor. We could make that motion day 3 weeks from today at 9 a.m.
What date is that?
That's February 22nd.
Attorney what's your last name?
McIntosh.
Attorney McIntosh, is that date all right with you?
If it pleases the court, certainly.
Attorney Stillerman?
Yes, it is.
No, say you have something on.
I'm sorry?
Say you have something else that day.
Oh, no, I'm sorry, that won't work for my schedule.
Okay. What
Is
date
it
do you
possible
have?
to have another date, the 27th of February?
The 27th of February. Well, now, that's going to be dependent on, we'll get back to the question of bail if Jerry's actually going to be held or not, because obviously then he'd be subject to bail review and have to be also brought before the court every 15 days. So that would be really time-consuming. So do you have an earlier date than the 27th?
The 19th would be fine.
How's that for you, Attorney?
Certainly, Your Honor.
The 19th? Okay, we'll go with the 19th. What about the issue of jury trial? Has your client waived his right to jury trial? Are you?
No, he is not.
Okay. Is that something you'll discuss with him at a later date?
Yes, I will.
Okay. I'll hear you on bail.
Your Honor, as mentioned, it's the Commonwealth's intention that the juvenile be remanded into state custody for, obviously, to the conclusion of the hearing. But he's with a past record. This isn't his first offense. He had run in with the authorities regarding a stolen wallet. Again, the police report, we handed it over there. And apparently, it's my understanding that the juvenile was not a model juvenile with regards to the probationary requirements with that offense. So you take that into account, coupled with this recent offense, and it's getting pretty clear from the state's perspective that this juvenile needs rehabilitation, which he is not getting in the custody of his parents. So with that in mind, we recommend that he be remanded into state custody for the purpose of rehabilitation, so no bail.
Let me hear for probation.
We agree with the council. It shows some pretty immoral matters. They seem to escalate actually back in.
He's currently on probation?
He is currently on probation. Even before that, he was.
Is he complying with the terms of his probation?
No, he was supposed to do 100 hours of community service. He's done about 40 hours. Supposed to meet with a counselor. He hasn't signed up for that. And as you can see, while on probation, he continues with his immoral behavior. Also, we have questions about the supervision at home. Considering the parents didn't even know that he was under arrest till 6 o'clock that evening. No notification.
Mr. and Mrs. Gottel, I'd like to hear from you. You both work?
Your Honor.
Mrs. Gottel.
The day Jerry was arrested for the lewd phone call, we weren't given any notice as to the fact that he was arrested.
Okay. What I'm concerned about today is whether I should release him to your custody. So you do. I know that you both do work.
Yes, we do both work full time, but I also have another son who's older, Paul, and he normally looks after Jerry. He has done a good job.
How old is Paul?
Paul is 25.
Does he work?
No, he doesn't work.
He stays at home?
Well,
Does he go to school?
He goes to school.
College?
Yes, and he's.
What college does he go to?
He goes to. Actually, he's in law school. He goes to Massachusetts School of Law.
Oh, really? So he would be home when Jerry.
By the time Jerry gets home from school, he would even have time to pick him up from school and bring him home, and watch him, make sure he does his homework until I get home to. Yeah, if I have to.
It's pretty hard work.
And Mr. Goff, do you work too?
Yes, I do.
I appreciate you both taking the time to escort your son.
Yeah, he's our son. We love him.
Yes.
Jerry, would you stand up, please? Jerry, you go to school?
Yes,
What grade are you in?
8th grade.
How do you do in school?
B's and C's.
B's and C's.
Sometimes
What's your
D's.
favorite subject?
Science.
You don't want to go to law school like your brother?
No.
You know that you have to come back to this court because you'll be asked through your attorney is asking for a trial on this matter, and you certainly have a right to trial, and you have a right to jury trial, and you have a right to speedy trial. That's why I don't know if you realize that I was pushing to have an earlier at least motion date. So if your attorney has any arguments to make to this court prior to the trial, she can do that. One thing that concerns the court is because of your prior sporadic, I guess, probationary history, and because it looks like you, at least it appears that you were unsupervised, the day of the alleged event. So this court has to be assured that not only that you would be supervised and not get into any more trouble in the interim, as well as assure this court that you'll come back. And I see that your parents are here, so there's a very good sign that your parents would bring you back for your next date. I am inclined to allow you to return home to your parents' custody and come back for your next court date. What, if anything, do you have to say?
Oh, the day that I got in trouble, Ronald made me
Well,
skip school.
Okay.
I don't hang around with Ronald
Okay.
anymore.
Today is not your trial, Jerry. At the time of your trial, number one, the attorney will advise you about your rights. You don't even have to testify. The burden is on the Commonwealth to prove the case beyond a reasonable doubt. You have a right not only to trial, but you have a right to jury trial, and that you can discuss with your attorney as well. So these, again, you'll engage with dialogue with your attorney and decide on the correct trial strategy. But again, I'm just concerned about any possible, you getting into any other trouble, whether it's at school, at home, in the interim. And I also want to make sure that you come back that day, because many times we put cases on and, neither the child nor parents, right, Lester? Come in and we're issuing subpoenas and so forth. Mrs. Gall?
I promised my mom and dad my grades are going up. I'm going to school every day.
We'll make sure he comes back.
Yes. Thank you. Attorney Stillman, is there anything else that you'd like to address?
Not at this point, Your Honor.
Okay, thank you. Attorney,
Again, just feel remiss if I don't point out to Your Honor that it doesn't, from the Commonwealth's position, that it doesn't appear to be any change. We'd just like to point out that the same level of parental supervision he was getting is now is what he was getting when he stole the wallet. The same level he's going to get now to ensure he gets back to a trial is the same level that he was supposed to get when he was supposed to be going to his probationary meetings. Based on history, I just don't see where he's going to come back unless there's change, which I'm not hearing now. It's the only thing the Commonwealth feels it necessary to bring to your attention.
thank you. Just the gist of it.
Excuse me, Your Honor, may I
Yeah,
address
sure.
the issue of the probation? Number one, the family nor Jerry had gotten any notice of the probation standards that he needed to comply with. And in terms of the incident where he was with a peer at the time that a wallet was stolen, he just happened to be in the wrong place at the wrong time. He didn't even know his friend was going to steal the wallet, and he never hung around with that child again. He realized that's wrong, that's not acceptable to him, but he didn't have anything to do with it. Unfortunately, he paid the price of that, of being put on probation for that particular incident. So as long as, unfortunately, there's been a problem with the notice for the family and himself, so as long as the family gets the correct notice in a timely fashion, they're more than happy to comply on his behalf. And he's quite aware of what he has to do once that arises, so they can follow it to the T. So there should not be another issue in terms of that.
So you and the family is assuring this court that the juvenile Jerry Galt will be complying in the future with the terms of his
Absolutely.
probation. Okay, thank you.
This court will assign custody of Jerry Galt to his mother and father under the conditions of Department of Probation, and the parties are dismissed. And will the clerk please call the next case?
You're free to go. Thank you.
You're free to
I'll
go.
see you in a few weeks, Jerry, and stay out of trouble.
Thank you so much for coming.
Good, all right. We did it a lot longer than usually these are really short, but that's okay. That's all right. Ready for the trial?
Oh, yes.
Oh, wow.
Okay. Tim, you're still are you still probation, Tim? You and Dennis? Yeah. You're still my clerk, Everybody else is still,
We rolling in right now to that?
yeah,
Okay.
yeah. Ash is Mrs. Cook, right? Okay, good.
Can't leave mom.
Now that's a good roll, man.
So you-
That's a meaty roll.
That is. Knew we'd see you again.
So in the interest of time, let's assume that y'all came back in, the introductions were done and so forth. And the Commonwealth has put on its first and only witness, Mrs. Cook. So you're going to begin, Jeremiah, with a direct examination of Mrs. Cook. And remember that she's the one doing the testifying, not you. So you'll ask, you'll start with preliminary questions to set the groundwork, who she is, what she does, etc. Trying to ask questions, what, when, where, how, why, so that it's her that does. At the same time, you don't want to leave it so descriptive that she ends up in this big long narrative. So you do want it to be a back and forth. John and Patricia, how about, okay, so that's, Jerry and his parents are here. So you're pretty much silent. But if any of you guys, including Joe, want to object to any questions, go ahead and object. And what you'll do is you'll stand up and just say object. And if I do, then you'll stop. So if you object it, I'm sorry, go ahead. What's your question?
Sorry, objecting in terms of
Okay, I'm
which side?
gonna tell you.
Okay.
Well, what side do you want to be on? Go over there. You're confusing me.
Okay,
Joe, you go on the Commonwealth side.
Yeah.
All right. So again, it should be Patricia and John, their counsel, objecting. But because you guys are just here as parents, you're not going to be having any speaking role. So if you see there's an opportunity to object, and Patricia and John are not, feel free to just stand up and say object, and pretend you're attorneys as well for Jerry. So if they object in time before Ash starts to answer, you're objecting to the question. Is it leading? Is it calling for hearsay? Is it a narrative? Whatever you want to object, because then I'm going to ask you what the basis for the objection is after you say objection.
So the rules of evidence apply?
Yes, yes. If he already answers, okay, you can still object, all right, to the answer as well, right? And I'll be, obviously there's no jury, so I don't have to instruct the jury to disregard the answer, okay? Now again, as I said before, yes, Ash, you're right, the rules of evidence do apply, but again, the juvenile court is still more informal than if you observed a superior court trial, or a district court trial, or a land court, or a probate family court. So you'll find, and I'm going to sort of try to play and different judges obviously have different personalities and different ways of doing things too, according to the rules. So I may, well, you'll see how my personality comes out as a judge. All right. So assume that she's already under oath, and you're just going to start with your first question, Jeremiah. Okay?
So, Mrs. Cook, where do you live?
I live at 29 Copeland Drive in New Hampshire.
To the best of your knowledge, who's the defendant?
I believe it's Jerry.
Where does Jerry live?
He lives about 4 blocks from my house.
Wait, can we just go off the record for a second before you start talking about Jerry? Besides where she lives, what does she do? Maybe she's even going to describe her home and the surroundings, because then you can lay the groundwork for them working on her yard and so forth. Okay.
But I was going to ask her how she knows Jerry, and I figured she was going to throw that in there.
Okay, but you're a little too soon jumping into the relevant facts. You want to do some of the preliminary stuff first. I'm sorry, and you also want to obviously establish through this preliminary questioning that what she's going to testify to is relevant, that she is aware of the facts and circumstances of what he's charged with, but also that she's competent to testify. I mean, you're not going to ask her age, but it's obvious that she's an older woman as well. So remembering the facts, it indicated something about her eyesight and all of that, and who she lives with. She's alone, but she's still able to do, you know what I'm saying? So you want to establish those sorts of things?
Mrs. Cook, what do you do during the day?
Well, I don't really do much. I live alone, and I just take care of my cat Matilda. But you know, I really don't do much. Some of the boys in the neighborhood come and help me out because I do.
Mrs. Cook, if you could just raise your voice a little bit so that the judge can hear.
Sure. I'm sorry.
I'm almost as old as you, so.
So some of the boys do come and help me out, and they take out the trash and mow the lawn. But I do walk every day. I am healthy. I recently had a.
Are you married?
No, I recently lost my husband. That was very hard for me because he used to do most of the chores. So now I do need help, but I do miss him greatly.
What was your profession prior to retirement?
I was a lawyer.
What, if any,
Lawyers make the worst witnesses.
You had mentioned you had cataract surgery.
Correct.
What, if any, medical conditions do you have affect your hearing?
No, I hear great. I just I recently had surgery in my eye, but you know, I can still see fine with my glasses, just as long as I do have my glasses. But you know, I'm fine. I can hear great. I'm in great health shape, and I do yoga once a week.
You mentioned some of the neighborhood boys come around and help you with chores. How often does that happen?
Object.
Judge?
Yeah, I know a judge very well that does it all the time.
Really?
One of you are objecting. Come on.
Hearsay?
What's wrong with the question? Repeat the question, John.
How, I said, you had mentioned that some neighborhood
It's
boys come
leading.
around.
Wait a minute. You can make your argument as to they're saying it's leading. Is it leading?
I'm building off of what she had already said.
Okay.
I'm trying to, Your Honor, what the Commonwealth is trying to do is trying to establish, the witness had mentioned, had stated in her testimony that she has boys in the neighborhood come over and help her with chores. It's the Commonwealth would like to find out how often this happens.
Okay. Overruled. You may answer.
Can you repeat the question? I didn't hear.
Earlier you had mentioned that some of the boys or men in the neighborhood come and help you with chores. You said mow the lawn and specifically take the trash. I believe the court reporter could read that back if you need to. I'm interested in finding out how often this happens.
They do it probably once a day.
Okay.
So specifically, there's a chore a day done by these neighborhood boys?
Not just by Jerry, but by other boys in the neighborhood. I usually see a boy a day that helps me with.
How many different boys?
Excuse me, why are you laughing?
This trial could very easily be going a different way here.
Don't let them go that direction. Narrowly focused.
See no problem with the whole
How many different neighborhood boys help you out?
Objection to my. Don't ask that question. Keep going.
Probably 5 boys in the neighborhood help me out.
To the best of your knowledge, where does the defendant, Jerry Gall, live?
He lives a couple of houses down the street.
And how do you know the defendant?
He just showed up one day and asked me if he needed help with anything, if I could help him, or if he could help me. And sometimes I tutor him with his math, and he takes care of Matilda for me.
How many times since you first met the defendant would you say you've met with him?
I've seen him probably. I've known him for about a year now, and I've seen him for, about 300 times, estimated.
In those 300 times, on average, how long does each visit last?
A couple hours.
Okay.
Do you pay Jerry and the other neighborhood boys?
Very little.
You do pay them
I do
for
pay
their
them.
chores.
Uh,
If you want to rest, we can go to cross. And you can do redirect afterwards. Do you have other questions, Councilor?
The only thing I was,
Go ahead.
gonna- I mean,
Go ahead.
I was gonna skip right into the phone call.
Oh, okay, go ahead.
Please explain to the court how.
Why don't you draw her attention to a particular day and just make up the date if you want.
On,
August 5th.
that's a long time ago. Okay, August 5th. Do you remember?
Speedy trial, right?
Yeah. Where were you August 5th, 2012?
In my home,
What were you doing that day?
feeding my cat.
Did you get any, no, I can't do that one. What happened that day?
Well, I received a disturbing phone call from what appeared to be Jerry. And he asked for the lady of the house, and I responded that that was me. And then he said, "You're not the lady of the house, you're a hoe." And they started singing, there was laughter in the background, and they said that they weren't gonna hoe my yard. I was offended that night and I couldn't even sleep. I was pretty distraught.
What did you do?
I didn't really do anything. I stayed home for a little while, then I called the police, and
Let me just interrupt. Did you know who the caller was?
I believe it was Jerry.
I was gonna get there.
Go ahead.
It sounded like Jerry.
I was gonna say, you had testified that the defendant's the one that called you on August 5th. What made you so certain?
Well, he stopped by my house 4 days ago, and him and his friend Ronald.
Had you ever spoken to Jerry on the phone before that date?
I have not. But I could recognize his voice.
You're biased. What disagreements, if any, have you ever had with a defendant?
I'm not sure.
Why don't you rest, because
Yeah,
we'll,
I rest.
a few questions on cross
Good answer.
before we.
Now, a short while ago, you had trouble understanding or hearing or remembering what the DA had asked you. Does that usually happen, that you have difficulty remembering or understanding what's being said?
I'm pretty sharp.
Okay. Now, you had never.
Remember, only ask a question that you know the answer to, and ask questions on cross that call for only yes or no answer. And they could be the form of a statement as well that they should agree or disagree with.
Now, you had said that you've never spoken to Jerry on the phone.
Correct.
So you wouldn't really know what his.
Don't go that far. He said it.
Okay.
Don't give him the opportunity to explain.
Okay.
Oh, but I've seen him 300 times a year. I've spoken to him so often that she. I'm sorry, Ash.
Okay.
She has never spoken to Jerry on the phone. Good. Leave it.
Now, you did say that Jerry and the other neighborhood boys came to help you quite often, like up to 300 times in a year?
Yes.
That's almost daily.
Correct.
So, why, but you feel that it was, why would,
Let me help you out here. You testified that you recently had a cataract operation.
I did.
You did. And Jerry actually came voluntarily to your house after that. He fed your cat. He made tea for you. Isn't that correct?
That's correct.
so it doesn't seem, like it seems like Jerry likes you and wouldn't do anything, did things to help you.
I like Jerry too. I didn't really understand why, a person like that who was so close to me would just go ahead and turn against me and make those comments. I didn't know where it was coming from.
Did you ask Jerry if it was him that had made the phone call before you went to the police?
I haven't spoken to Jerry since the phone call.
And did you speak to his parents and ask them if that was if they could speak to their son to verify whether that was him and to take action if it was?
No, I went straight to the police.
Redirect. Any other questions?
This is
So we
just
can
the
wrap
yes or
this
no
up?
Stuff, right?
What's that?
This is just the yes or no stuff, right? This is just yes or no questions on cross, right?
On redirect?
To redirect?
No, you can do whatever you want.
The only thing I was gonna do, if you wanna cut it to chase, I was just gonna sum up what it already. Yeah, here's it then, 300 times again.
Why don't you each do a quick closing,
Okay.
unless you want to ask a question or two.
There seems to be this disagreement with counsel on your contact with the defendant, so I just want to clarify. It was your testimony that you have been visited by the defendant approximately 300 times over the past year, each visit lasting a couple hours, and you interacted with the defendant during these visits.
Correct.
Okay.
Can I ask a
All right.
question?
Go ahead.
So the extent.
I want to hear you guys do a closing really quickly. That's why. Make it quick.
So your personal knowledge of this telephone conversation is that you received a prank phone call and you heard those comments, but it doesn't. You don't have personal knowledge other than that of who was making the phone call.
Just from the phone call, just from the whole comments.
That's it.
All right. Want to close?
Closing, sure. It's Commonwealth's position that the witness had 300 visits over the past year, lasting 2 to 3 hours each visit. So if you do the simple math, that means the witness has spent anywhere between 600 and 900 hours with the defendant over the course of the year. To say that the witness would not recognize the defendant's voice with no known medical condition affecting her ears is absurd. It's pretty clear who made the lewd phone calls, and she was in every right to call the police.
Jerry's counsel?
It's our position that there's absolutely no verification as to who actually was making that phone call. That you received a phone call is unequivocal, but who did it? Jerry claims that he didn't. He spent so much time with you doing things for you that it just seems so unlikely. It seems impossible that he would have been the one that did it, and he denied it. And you've never found, Jerry's never been dishonest. He's always been around your house helping you. There's never been any other incidents related to you that was negative.
All right. You're not talking to the
okay.
defendant, the juvenile. You're making a closing argument to the court, but that's okay. All right. What should the court do, real quick? So Jerry, took the 6th. Took the 5th. Didn't testify. The substance of the trial was Mrs. Cook. Commonwealth has to prove the elements of the, offense beyond a reasonable doubt in order to proceed to adjudication. So number one, before we get to what should we do with them, disposition, what should the adjudication be? And I'll leave that open to everybody here.
I don't think they've actually proven that he made the phone call at all.
So you don't think the Commonwealth met his burden? Even Jeremiah, the Commonwealth is
Quick question. He'd said earlier in the first trial, he'd mentioned that he did admit to making the phone call, just not saying the words.
Okay, but this is the trial, remember?
Okay, so that's not true in this case.
That's correct. That's correct. He took the 5th. We're not hearing from, other than, and that would have been hearsay if you put the officer on the stand anyway.
Yeah, despite the fact that I remember that, if that testimony was in, that's a whole different ballgame, because now he's in.
Absolutely, yeah.
But he's
Without
willing to die
that,
on him.
without that testimony.
And if and by the way, if there had been pre-trial motions before this date, there would have been a motion to suppress, okay, and that confession would have been suppressed because it was a violation of his constitutional rights.
600 to 900 hours of interaction per year, it amounts to very strong circumstantial evidence.
It would sound different on the phone, though.
Right.
Very
So
different.
circumstantial,
The fact that she
but
never
not-
talked on the phone?
Yeah, it's close because she does know him very well.
Right.
In spite of that, she's elderly, so she has eye issues, but she doesn't have a hearing problem. She still drives and everything.
I was trying to bring up any arguments to prove that she didn't have any bias. She wasn't out to get him.
And she made a good witness. She got herself here. She didn't appear to be, hateful or any. She just was. This is what was done. I know him. Blah blah.
But if she had that kind of hands-on experience for that number of hours. You would think that she would have, number one, confronted him personally and spoken to the parents. Because obviously she thought he was a nice young man, or she wouldn't have let him be at her house.
Okay, now
so
that would have been
often.
an issue if you wanted her to testify about that, because she's testifying about the event itself. So that there would have been objections, which I probably would have sustained, because they would have been both irrelevant and prejudicial. She's only testifying as to her own, knowledge of what he's charged with. So more than likely, I wouldn't have wanted to hear that.
Yeah, I think everything here was circumstantial and doesn't meet the burden of proof.
Up beyond a reasonable doubt.
Yeah.
What Patricia just mentioned, that would have been probably good for a closing, to throw that type of stuff in.
Sure.
Okay.
Yeah. Now, I don't know. What do you think, Lester? As I said, it's close. I might find that the Commonwealth has Menace Byrne. This was a very good witness. Again, I observe. I have a lot of discretion, so I observe her demeanor. Do I know that he skipped school that day? I don't.
See, the other
right?
thing with the testimony
That
sheet that I did, from my role, that should have been taken out, was she admitted there was a lot of noise in the background. Heard other voices in the background. And so without his testimony saying, I dialed it, but somebody else was,
Right.
it kind of hurt my position when she admitted she was hearing other people in the background. So now it's like, I'm glad they didn't go there, because if I was on the other side, I would have asked, who else was in the background? Well, I don't know. How can you recognize
Now,
his voice but not hers?
we're running out of time. Let me just say quickly now. In any event, even if the Commonwealth has proved its case, that doesn't mean that I, as a juvenile court judge, post-Gall, will do the same thing that Judge MacGyver had done. It's very low on the threshold of criminal charges, making a lewd phone call. Yes, he's on probation. The probation is for minor things, even though he's been iffy with the terms of his probation. So I may end up not even adjudicating him delinquent. I might just continue the case without a finding, place him probation for a year, as long as he's not in trouble in the next year or so. And we'll get into the adjudication, disposition, and all of that much later on with the delinquency. What you should take away from here is the absolute due process rights that juveniles post-Gall have relative to the adjudicatory, what this was, proceeding of a delinquency case. The notice, the right to counsel, the confrontation, and the privilege against self-incrimination that flows from that. I'm going to send you all an email, because next week we're going to actually start with the exercises that are at the end of the reading. So there's there's a hypothetical three class exercises. Your last case is Stone, Commonwealth v. Stone. The exercises come right after that. So I'll send you a reminder email. So when you read the first set of cases, we'll start with exercise number 1 and get it, and maybe start 2, and then on Thursday we'll do exercise 3.
You just said something. You said post-Gall juveniles have absolute due process. So if they wanted, they could have called him up and questioned him as well.
If he wants to take the stand, he'd be strategizing with his lawyer whether he should or he shouldn't.
Okay.
Absolutely, that's his right. Yep. Joe, I have my computer here because I'm still having a problem with your email. Can you come here for a second?